Selling synthetic drugs could land you behind bars for years, and the future of 2 constitutional amendments are in the hands of the court. We hear arguments for each case in this week's Capitol Report. Hello, everybody, and welcome to this week's Capitol Report. I'm Julie Bartke. Minnesota legislators and law enforcement officials were on hand for Governor Mark Dayton's mock bill signing of legislation making it a felony to sell certain synthetic drugs. The new law stems from an increase in the sale and use of the drugs, particularly in one Duluth area.
We've seen an increase in the behavior, agitation among those that are using it, as well as depression, suicidal thoughts, as well as many of the other things that go along with using this drug, such as sickness. Businesses are frequently having to clean vomit and other bodily fluids up from their storefronts near this business, and they've had it.
And this is what we're talking about here. I'm great at bringing show and tell because I wanted to show you truly what it is that Chief Ramsey finds up in Duluth, Minnesota, what we found out in Rogers, Minnesota, just a few miles here from our state's capital. This is what the young people are going into these head shops or these local businesses to purchase in what on August 1st will be illegal in the state of Minnesota.
The chief author of the bill that expands the penalties for synthetic drugs joins me now, Senator Scott Newman. Thanks for joining us at Capitol Report.
Thank you for having me.
Let's begin with this bill, which will be a law effective August 1st, but essentially selling synthetic drugs was already a crime. Why make it a felony instead of a gross misdemeanor?
Well, for a couple of reasons. I think you have to go no further than to look at what was going on up in Duluth and the consternation that that community was in over the sale of these drugs would go a long ways to answering your question. The other thing is that they're just flat dangerous. I mean, the folks who buy these, and oftentimes they're youngsters, you literally don't know what it is that you are buying. And the idea that these bath salts or synthetic drugs are being put together, you literally do not know what kind of chemicals are in there, and you don't know how they're going to affect affect your body. They're literally poisonous.
For the sake of our viewers, why don't you go into a little more detail about what happened in Duluth and what precipitated your attaching your name to this legislation?
There is, and there still is, a store up in Duluth, down in the business area, and the guy that owns this got into selling what are called bath salts. Some people call it synthetic marijuana, but they're synthetic drugs. And all you have to do is watch the news a little bit, and you will see that they are having a devastating effect on people, literally killing people. The problem is that we have got laws in Minnesota that list what are called controlled substances, i.e. they're illegal. And so what this guy in Duluth and others, other misguided people, were doing is they're changing the chemical makeup of the compound a little bit. All of a sudden, it's no longer a controlled substance, therefore not illegal. So what we are trying to do with this law, and the law that we passed last year, is to stay ahead of them. And it's a bit of a foot race, I've got to admit. But in order for a substance to be illegal, such that you could prosecute for it, for the sale or the use of it, is you have to be able to somehow define it. And that is the real difficulty in this, is when they change the chemical compound by a little bit, all of a sudden it's not listed on the schedule of controlled substances, therefore it's not illegal.
And the Board of Pharmacy is going to have quite a hand in determining what is an illegal substance under this new law as well. Why give them the authority?
What we're trying to do, and the authority that the board has is frankly quite limited. I mean, they are being given some expedited authority where they see a drug that, for instance, doesn't have any legitimate medical purposes, and there are some other criteria, then they can move faster than the legislature in adding this compound to the list that is illegal. But also remember that this is a very limited authority that we gave them, and they do have to come back in front of the legislature and justify what they have done. So I'm pretty comfortable with that expedited, very narrow authority that we have given them.
You said, oh, go ahead, I'm sorry.
And I was going to say, we need the help from the Board of Pharmacy because they understand the chemical compounds, and I will guarantee you that us legislators do not.
And let's talk a little bit about this foot race that you brought up. Essentially, as it was stated in that news conference, the Board of Pharmacy, when it might identify a new drug, a new chemical compound that perhaps wasn't already covered, there's a bit of a lag time before that drug could be incorporated under this legislation. They stated about 3 to 4 months as a timeline. So as far as this foot race and trying to keep up on this war against drugs, how much closer do you think this legislation gets authorities?
Quite a bit closer, and here's the reason. Instead of listing drugs by their chemical makeup or chemical compound, we have now listed drugs on the basis of what are being called analogs. I'm not too sure what that means, except in layman's terms. We now have a law in place that will look at a drug as how it affects the brain receptors, as opposed to how it is made up from a chemical standpoint. That's important for when the BCA gets into court. Their experts, their druggists, will be able to testify this particular drug affects the brain, the human brain, in the same method or in the same way as this other compound, which is illegal. Therefore, it's an illegal drug. It is somewhat of a novel approach. I am sure it's going to be contested. But like I say, it is a foot race to stay ahead of these misguided people, and we're doing our best to do just that.
The law also, it works for people who are trying to sell these drugs, and not necessarily those who are in possession of. Why not expand it to possession and make that a felony as well?
Well, we're really not after and these are mostly young people that are ingesting these. We're not after that. That's not what we're trying to stop. So we left that as a misdemeanor. But what we did do is we raised the sale to a felony where it wasn't before. And it's the folks that are selling it and making money off of selling these poisons to our youngsters. Those are the folks that we're after.
So, Senator, what do you want to say to Minnesotans, parents and kids alike, when it comes to these the issue of these synthetic drugs that seem to be permeating these days?
Be very, very careful, because although these are being advertised as synthetic marijuana or bath salts, which are really pretty harmless sounding substances, the truth of the matter is that they are poisonous and they are dangerous. People are dying from them. There are folks who will go through a hallucinogenic episode because they have used these. These are really dangerous, and I would encourage parents to pay attention to what's going on, and I would encourage youngsters to really think about what it is that you are ingesting, because like the meth from a few years ago, it's poison.
Okay. Senator Scott Newman, with those words, thank you for your time today. We appreciate it.
Thank you very much.
This hearing by the Senate State Government Innovation and Veterans Committee delved into the Secretary of State's handling of 2 ballot questions that go before voters in November. Some GOP committee members questioned whether the Secretary of State is using his office and public dollars to defeat the voter photo ID amendment. DFL lawmakers defended his work.
Is it a violation of his oath of office to travel around the state being an opponent to a piece of legislation on elections that the legislature voted? Should the taxpayers of the state of Minnesota be responsible for footing the bill? Presumably, he has to get there somehow. And if he's doing it during office hours, during normal office hours, he's on or being paid in his salary his official duties as Secretary of State, and yet he is being an opponent of a piece of legislation that we passed.
I think that is definitely his duty. It's his duty to tell people what he thinks this law will do and how it'll affect the voting system in Minnesota. And he is a separately elected official from the governor. He may be part of the executive branch, but he is a separately elected constitutional officer. And the people then elected him, trusted him to make sure that their voting system was fair and equal and that everybody got a chance to vote as easily as they could.
And I would submit that there is only one reason to not accept the title from the legislature, and that is that the Secretary of State, who has made his position on this issue very clear. Nobody can deny that the Secretary of State opposes this photo ID amendment, is changing the title in a way to help his side of the issue succeed. We in Minnesota have a right to expect better.
Steve Senek sat down with Senator Mike Parry following the hearing he called on the issues.
Senator Parry, welcome to Capitol Report.
Well, thank you very much. It's good to be back.
The legislature exercises its authority by convening meetings. It brings issues to the light of day. And what were you trying to bring to light of day regarding the constitutional amendments with your recent hearing?
Well, I think because of the response that we were getting from citizens throughout the state about what in fact is the duty of the Secretary of State when it comes to the constitutional amendment. Is he actively campaigning with taxpayer dollars on taxpayer time to try to overturn this amendment? And why is he not representing the state of Minnesota? On the other side, with the Attorney General, why is she not representing as our Attorney General the Secretary of State in these proceedings?
During the hearing, the DFL members said, well, he's exercising his authority as the Secretary of the State. He should weigh in on how he sees the impact of constitutional amendment on, if it was supported by the voters, what would happen. Do you agree with that?
Well, there comes a point in time where, yes, you can weigh in, I believe, but it's how are you weighing in? Are you weighing in with information that is not even a credible source of information at this time? Because the constitutional amendment has not even been put to the voters yet. Once it's put to the voters, I think at that point in time our Secretary of State comes back with the next legislature if in fact it's passed. And if it is, then the legislature then at that time we'll make the decision on the photo IDs and how we move forward and how we administer. But to bring that up now, to me, is a moot point.
The issue we're talking about is a voter photo ID constitutional amendment. And Secretary of State Mark Ritchie, he ran as a DFL legislator. And DFL legislators in the Minnesota legislature and across the country largely do not support this initiative. Don't you think the public kind of expects him to act in this manner?
Well, I think the public kind of expects the governor to use a bully pulpit in his position when he's out and he does not like something. When it comes to a constitutional amendment, it's, I believe, up to the Secretary of State to educate the voters on the amendment and not try to look down the road before the amendment is passed. I think there's a fine line. There's a fine line when it comes to campaigning, which is one of the issues that we talked about in the committee under, I think it's Chapter 10A01, Subdivision 9. Is he using campaign expenditures to do what he's doing? And if so, has he violated the campaign laws by not having reporting? Is he using taxpayer dollars? These are the questions that the citizens want to know, and his refusal and the Attorney General's refusal to appear before our state government committee is totally unacceptable. And the citizens of the state believe it's unacceptable for them not to show up.
When he ran for public office, he ran as a DFL candidate. Why do we allow office holders who, based on your argument, should act in a nonpartisan manner? Why do we allow them to run under a party label?
You know, that's a good question. If Jesse Ventura had his way, we wouldn't have to worry about that now, would we? But I don't know. Steve, to be honest with you, I think if whether you're DFL or Republican, specifically in the case as the Secretary of State, I believe you have to move your agency forward in a very nonpartisan way. And that's what I think is concerning to the citizens that have come forward.
On the issue of the topics, there was a couple press conferences called by GLP members that questioned the Secretary of State's actions on establishing a topic title for these constitutional amendments. They said the legislature did that, and therefore he should not have done that. But do you think the titles that he chose dissuade voters from supporting those amendments?
Well, it creates a question, an uncertainty. It's not clear what his question really is. And so I think that does dissuade some voters. But I think the Supreme Court, I will be very disappointed if they come back and say a statute trumps the Constitution. And I don't believe they will do that. I think they will uphold our case. But most importantly, I think when you read into that, the legislature, over and over and over again, specifically in the Senate when we were talking about this voter ID, photo ID, we specifically had a title, and that was in part all the debate was on the title and why. And so we set forward the intent. This is the way it should be, and we don't believe that Secretary Ritchie has a right to change that.
On a separate lawsuit brought forward by a few organizations, the issue was on the amendment. The amendment is longer with verbiage compared to the question that's put towards the voters. Specifically, the amendment talks about provisional ballots. It talks about government-issued photo IDs. But the question's much simpler. It says, all voters, including those not voting in person, must be subject to substantially equivalent identity and eligibility verification prior to a ballot being cast or counted. It doesn't talk about provisional ballots. It doesn't talk about government-issued photographic identification. Why didn't the legislature simply just put the amendment before the voters rather than rewrite the provisions of it into a question?
Well, I think we were looking at other cases around the United States that were moving forward at the same, and those had won Supreme Court battles. And Senator Newman has been a champion in this, and you know, he would probably be better served to answer that full question. But I do know that was part of the background of that.
Do you believe, when it comes to constitutional amendments, and the legislature puts those forward on the ballot, the governor doesn't have the authority to stop the legislature from doing that, do you think that that process should require a supermajority vote by the legislature? In other words, that may force the issue to be more bipartisan in nature.
Mm-hmm. Well, you know, that's a very good question. We talked about it before we went on here today, and I guess there's one area that I'd probably have to agree with my colleague Senator Bach. I believe there needs to be good bipartisan. I'm for one, I get concerned if we really get into legislating by constitutional amendments, and I think a lot of the citizens are somewhat concerned about that. So, Steve, I guess I would have to agree with that.
What will your committee do in the coming months? I mean, this issue isn't over for you.
No, it's not. You know, I'm still concerned. I mean, we sent out specific questions. Here's some. Is the information Mr. Ritchie providing accurate and unbiased? How much has Mr. Ritchie billed taxpayers for his travels, his meals, his expenses? These aren't questions coming from Senator Mike Parry. These are questions coming from citizens who have called and said, we have one taping on a radio talk show where an election judge called the show, and she was very upset that for the first 20 minutes of, and I believe this happened in Alexandria, for the first 20 minutes of their the Secretary of State's talk on election judge, the training, was all against voter ID. How bad it was, what it was going to do, that it was going to cost millions and millions of dollars, that everybody's going to have to buy the electronics, they're going to have the internet. All of this information is coming back to us, and people are concerned about what's happening, what is right, what is not right. And so, you know, that comes to the other statute we've looked at, is 211B06, false political and campaign material. The penalty is a gross misdemeanor. If we, through this investigation, find information that would push us to file a complaint with OAH, that we will do. But we're gathering information. Right now we're waiting for the Supreme Court to do their job, oral arguments, but that really has nothing to do with what my committee is looking at right now.
An investigation, your committee is conducting an investigation currently. Is that accurate to say?
That's correct.
Well, Senator Parry, we'll keep monitoring your committee, and for future hearings, we'll make sure that we're there.
All right.
Thank you for your time.
Thank you very much.
Senator Barb Goodwin challenged some of the assumptions made during that state government meeting. She joins me now to talk about those. Thank you for joining us.
Thank you, Julie.
Senator, let's begin with your point that was made during the hearing. It was essentially that Secretary of State Mark Ritchie ran and was elected as a DFL candidate for the office of Secretary of State. DFL legislators and Governor Mark Dayton did not support the proposed amendments passed by the GOP-controlled legislature. You believe he's doing his job. How so?
I do. Well, first of all, there's a statute that specifically says that the Secretary of State shall title an amendment to the Constitution. So he's not asked to do it, or maybe he should do it, but it's definitely by statute since 1919 part of his job. And up until this point, there's never been an argument or disagreement about that. The Secretary of State did approve a legislative title on the Legacy Amendment a few years ago, but that was the first time in history of the state that the Secretary of State had not actually written the title him or herself. So it is his job. It is his job, definitely, and there should be no doubt about that. And there's no similar proposal that says that, or statute that says that legislators can title the amendment. It only applies to the Secretary of State. That's his job.
So do you believe that the titles that were chosen by the Secretary of State could dissuade voters from supporting these amendments? And do you think that's an issue in all of this?
I don't know. I'm going to leave that for the court to decide. I think that the title should reflect what's going to be the result of that too. And all through the session, we were trying to get a better explanation or some layout of what this means to people and how it's going to work and how people are going to have absentee ballots, and are they going to send photos in or whatever, and how people are going to afford, if they have to get a copy of their birth certificate or their marriage certificate or whatever, they do. This statute won't cover that. It'll cover the free ID, picture ID, but it won't cover any other costs that, so that's like a poll tax. So we said, let's spell this out a little bit better in statute. And so we know what it's going to look like for people. People know what it's going to look like when it gets done, but that was not allowed under the majority in the Senate.
We interviewed Senator Parry a little bit earlier in the program on this issue, and he stated that he believes people expect the governor to use the bully pulpit on issues that he opposes. But Senator Parry feels it's the duty of the Secretary of State to educate people on the amendment proposal and not to look down the road on whether or not the amendment passes. So what do you think?
Well, I think that's a pretty mixed message there, because there's no possible way that you can actually inform people about the amendment without telling them how the good and the bad things about what might happen with it. And I think it's his job. I mean, his job is to it should be to make the voting process as simple and clear as possible to people. And if he believes that this is not simple and clear, as I believe, then I think that is his right to express that to people, because he's the one that's hired by the citizens of Minnesota to oversee the election system and the voting system, and they know that when they elect him.
And I'd like to challenge you a little bit on that statement. You're talking about him overseeing the voting process. Do you think this issue is related to process, or is it more about the issue?
It's definitely about process, because it's going to change the entire process for voting. We don't even know yet whether or not a driver's license will be an acceptable form of ID, for example. Possible that it will, but also possible that it won't. We don't know if a state ID, not a driver's license, but a state ID is under this provision. We're still not quite sure whether military, and I know it says government issued, so maybe military IDs are going to be accepted, but there's so many unknowns in there.
What about with the other amendment, the marriage amendment? That doesn't necessarily have anything to do with the voting process, and yet he has also proposed changing the title on that as well.
Yeah, and again, I suppose that would be just under the fact that it is his duty to write the titles, and he decided that the title of that wasn't descriptive enough for the public. And so whether or not he's right or wrong, I guess the court will decide that. But
okay, Senator Parry, he did pose this question as well when we interviewed him. Is the Secretary of State, in effect, campaigning against these ballot initiatives using tax dollars? How would you answer that question?
I don't think he is, quite frankly. And I remember all the years, 24 years or whatever it was, that Joan Grow had the office of the Secretary of State, and she went out and talked to people about voting and she worked all that time to try to simplify the process for voting, and we're very much one of the top states for people that go out to vote. And so as far as that amendment, he has the right to change the wording on it, and more power to him. The system of checks and balances is so important. We can't have legislators going in there and saying other constitutional officers can't say this or that, or can't do this or that, because that totally interferes with our checks and balances. And I'm glad the legislature decided back in 1919 to do this, because it makes it a more fair process. The way it is, they get to bypass the governor with an amendment. And they're using amendments to our Constitution, which they claim Constitution is so important, to discriminate or to make it harder for people to vote. And doing that will definitely have a negative impact on our Constitution, and people need to respect that document. And so if you say you want people to go by the Constitution, but then you want to remake the Constitution into your own personal views, that's something that hasn't been done before, and that's what bothers me most about this.
My last question for you, Senator Goodwin, is should constitutional amendments, legislation anyway, constitutional amendment legislation, in your opinion, should it be passed by a supermajority?
Absolutely. I absolutely believe that, because it's so important. What goes on the ballot is so important. And we do want people to understand it. And even with a legacy amendment, I'm not sure they understood everything that would entail, because it's a lot of money for a lot of years, taxpayer money. So I'm not sure they did. And, we want them to be able to understand totally what they're doing, because once it goes in the Constitution, it's very hard, almost impossible to get it out. In fact, I don't know of cases. There may be some in Minnesota where sometimes, because something became totally outdated, they were removed from the Constitution, but on farming or on something. So yeah, I think it definitely is a supermajority or a governor's veto. This is something that didn't happen when Pawlenty was in power for 8 years, and even when the Democrats had the majority, we didn't bypass him by going to a constitutional amendment when he didn't like a bill of ours. We normally didn't even send bills over that we knew he would veto, because it's a waste of everybody's time. But we certainly never bypassed him with a constitutional amendment, and I think that the process is important, and keeping the process clean is very important.
With those words, Senator Barb Goodwin, thanks for your time and your perspective. We appreciate it.
Thank you, Julie. I appreciate it.
It's now easier to stay in touch with activity at the state capitol. Senate Media Services is on Facebook, YouTube, and Twitter. Find the links on our homepage. So follow us and follow the Senate. That concludes this week's Capitol Report from all of us at Senate Media Services. I'm Julie Bartke. Thank you for watching.